You are listening to the Rule of Law Radio Network at ruleoflawradio.com. Live free speech talk radio at its best.
Eddie Craig. It's traffic night anyway for Eddie's night here on the Rule of Law. And Eddie, you want to discuss a legal black hole that you have found.
Yes, I do. It goes hand in hand with what we talked about the other night, dealing with Article 1406 and 1517 of the Code of Criminal Procedure. Now, let me lay this out for you the way it works. Chapter 14 deals with an arrest without a warrant. And it specifically names the things for which a person can be arrested by order of a magistrate or something committed in the presence of a peace officer or another civilian. 1517, the Chapter 15 covers arrest with a warrant. Now, 1406 and 1517 overlap with each other. The arrest without warrant only occurs up until the point where you are taken into custody. At that point, 1406 and 1517 converge, because everything done from that point on, the moment you're in custody, is exactly the same. And 1406 specifically references the magistrate and the officer to proceed forward under 1517 to do their thing. Now, this leads us back to what we normally talk about, which is Section 543 of the Transportation Code, where the officer is allegedly allowed to authorize for any violation of Subtitle C. Now, what we're going to see tonight is, I do believe that we can show absolutely that these people are committing high crimes and misdemeanors against the citizens of Texas for arresting them under an administrative charge. Not a civil penalty, not a criminal penalty, but an administrative penalty. Now, where they got the authority to think they could arrest for an administrative charge is beyond me. But I'm going to show, by what I'm going to present to you tonight, that Article 1406 and Article 1517, by their own language, may not be used in the event of a traffic citation. So, in the event of a traffic citation, what is the proper procedure? Because 1406 and 1517 will not apply. And I'll show you how that works. Let's first look at 1406, arrest without warrant. In subsection A, except as otherwise provided by this article, in each case enumerated in this code. Now, we talked about this last time. It's specifically talking about things enumerated within the Code of Criminal Procedure. The person making the arrest or the person having custody of the person arrested shall take the person arrested or have him taken without unnecessary delay, but not later than 48 hours after the person is arrested, before the magistrate who may have ordered the arrest, before some magistrate of the county where the arrest was made without an order, or to provide more expeditiously to the person arrested the warnings described by Article 1517 of this code, before a magistrate in any other county of this state. The magistrate shall immediately perform the duties described in Article 1517 of this code. Now, that is subsection A of 1406. Subsection A of 1517 specifically goes through everything the magistrate is supposed to do once the accused is before them. All right? Now, let's look at 1406 subsection B. A peace officer who is charging a person, including a child, with committing an offense that is a Class C misdemeanor, other than an offense under Section 49.02 Penal Code, may, instead of taking the person before a magistrate, issue a citation to that person that contains written notice of the time and place the person must appear before a magistrate, the name and address of the person charged, and the offense charged. Now notice this specifically says an offense that is a Class C misdemeanor. We also notice that a great number of the offenses under the Transportation Code are just said to be misdemeanors, not Class Cs. They simply say misdemeanor. And in some instances, but very few, it actually classifies them as a Class C misdemeanor. Why the disparity? Why does the legislature have enough brains in one section to actually state Class C misdemeanor and have a total aneurysm in the other section where they can't seem to do anything but just say a misdemeanor? That leads to question number one, which is, why is there a disparity here? Now, subsection C of 1406, if the person resides in the county where the offense occurred, a peace officer who is charging a person with committing an offense that is a Class A or B misdemeanor may, instead of taking the person before a magistrate, issue a citation to the person that contains written notice of the time and place the person must appear before a magistrate of this state as described by subsection A, the name and address of the person charged, and the offense charged. Now, subsection D. Subsection C applies only to a person charged with committing an offense under Section 481.121. Okay, that's the Health and Safety Code. Section 28.03 Penal Code. Section 31.03 Penal Code, Section 31.04 Penal Code, Section 38.114 Penal Code, Section 521.457 Transportation Code. Now notice, subsection C applies only in these cases right here, these particular offenses. Okay? Now the one thing about 1406A, it says, except as otherwise provided by this article in each case enumerated in this code. Well, what is it calling a case in this code? Because the only thing I can see that speaks to an actual offense in the Code of Criminal Procedure is the sections dealing with jurisdiction and statute of limitations. So what are they talking about when they say in each case enumerated in this code? Are they talking about the items here in subsection D? What are these things that they're enumerating that exist only in this code? It's hard to say. It doesn't clarify where it's getting this enumeration from. But the Code of Criminal Procedure does not enumerate an offense. It simply states who has jurisdiction of a given type of offense and what the statute of limitations are on a particular type of offense. So what are they talking about? Now, let's flip over to 1517 for a moment. And just for the sake of argument, let's just go ahead and say that subsection A tells the magistrate everything he is required to do under the provisions of 1517 when a person is brought before him. And if you read it, you'll find that that's pretty much exactly what it is. But if we go to subsection B of 1517, subsection B's language appears to nullify the activities of subsection A if, after an accused charged with a misdemeanor, punishable by fine only, is taken before a magistrate under subsection A of this article, and the magistrate has identified the accused with certainty, the magistrate may release the accused without bond and order the accused to appear at a later date for arraignment in the county or statutory county court. Now, the reason I say that they have to skip subsection A and go with just what's in B is because in subsection A, they take a plea from you. Now, it's my understanding